orders, item number 1.
Anyone for the private respondents?
They have not been represented.
Okay. Anyway, I think we'll allow it. Right. And then will you take steps afresh on the appeal?
Yes.
Okay.
Yes.
Okay. Right. Yeah? What is it? Heard Mr. Silaram Zawa, learned senior counsel for the applicant, who submits that there is a delay of 30 days
30 days.
in filing the appeal against the impugned judgment and order dated 21/11/2024, passed in WPC number 103/2023. Ms. Lalnundui,
Your Lordship,
GA appearing for
I am paying for the state respondents, Your Lordship.
appearing for the respondents number,
10 and 11, Your Lordship.
appearing for the respondents number 10 and 11.
Your Lordship, I would like to make a submission that I have received information that the compliance has been made for the order.
The order has been complied with.
Yes, Your Lordship. If I may submit the copies, Your Lordship, that I received.
Anyway, we'll let us dispose of this. Ms. Lalundri appearing for the respondents number 10 and 11, and Ms. Zairem Sangpui, CGC, appearing for the respondents number 8 and 9, submit that they've got no objection to the application being allowed. No one appears for the respondents number 1 to 7, though notice was issued to them on 14/2/2025. On considering the reasons given for the delay in filing the appeal, we find that sufficient cause for the delay has been made out. The I is accordingly allowed and disposed of. Then in the main appeal,
Your Lordship, at page 9 of the Memorandum of Appeal, the points which arose for decision before the learned single judge is the page 9.
yes,
These are points such as A, whether levying of cess at the rate of 10% from the cost of the land as awarded by the collector is right and proper. B, whether the writ petitioners are entitled to payment of interest under section 80 of the Act of 2013, if so, from which date. C, whether the market value of the petitioner's land should be enhanced at par with the rates admissible to other parts of the state. So far as all these issues are concerned, it has been decided in favor of the writ petitioners. And the instant writ appeal is only in respect of A. We are not challenging the the judgment and the decision.
you're only challenging the
B
cess.
and C.
Huh?
We are challenging cess. Challenging cess in the sense that cess cannot be levying of cess from the cost of the land as awarded by the collector is right, we said. And the
Is right.
it
It's
is-
correct.
It is not right as held by the learned single judge.
Okay,
So we have challenged this.
so it was asked to be returned. The cess was asked to be returned, correct? Is it?
Yes, that's true.
So cess is to be returned.
Yes,
So you're challenging this portion.
yes, Your Lordship.
Yes, and when was the award made?
What was 2021?
2021.
Yes,
Under which act?
under the Act of 2013, the Central Act.
2013.
Yes, Your Lordship.
And the award was made in
2024.
24.
Yes.
You said 21, now 24?
Award number 5. Yes, award number 5, additional 1 of 2024. Lordship, I've made a mistake.
When was the writ petition filed?
Writ petition,
Writ
was
petition filed is of 23. How can the award be of 24?
Lordship,
5 of 21.
Award number 5 of 21.
Additional, not,
5
1
of,
20.
yes, Your Lordship,
Award number
5 additional.
21.
what is it? Additional award or award?
Yes. So far as this writ
Yes, what?
petitioners-
Yes, what? Yes.
So
yes.
far as
correct? Yes,
it is
not
additional
correct.
award.
Additional award.
Additional award. So far as this.
So, when
private
was the
respondents
earlier
are
award
concerned.
passed? What was the earlier award? Earlier award, what's the number of the earlier
Earlier
award?
one is, Lordship,
Because addition award is just a continuation. In addition to the earlier award. So, what is the earlier award?
Draft award was of 2020.
earlier one is there, so since these writ petitioners were not included,
No, no,
Yeah,
it does
so
not
for it-
matter included or not. When is the earlier award passed?
you know. 121.
So in that award of 2021, this 10% cess was deducted.
Lordship, may I take Lordship to page 121?
No, this addition, this is where they are included in the additional award. no?
Additional award.
Additional award number 5.
5 of, award number 5, additional dash 1 of 2021.
Award number 5.
Additional dash 1 of 2021.
Additional 1.
It is award number 5 of 2020.
2025.
21.
2021.
Award number 5 of 2020, at page 121, Lordship. This is the award, the original award.
121.
Yes.
121 is the original
Original
award number 5 of 2020.
Yes. Since
Now-
petitioners were not included.
Okay. So the petitioners were not included here, so they were included in the additional one,
Yes, Your Lordship.
in the additional award.
129.
On
29.
which one?
Additional award.
Additional one. 129. So cess was
132.
Cess was awarded and then,
cess was taken
yes, taken. 10% cess was taken. As
in
per
terms
the-
of subsection 2 of section 23.
Yes, Your Lordship.
Let us see this section 23 too.
If I take a Lordship to page 71. Page 71.
Yes.
Says charges, costs and other revenues. That is in the middle of the page. At page 71, Lordship.
This is made under what provision?
This is under the
Mara Autonomous
Autonomous
District
District
Council
Council.
Land and Revenue Act 2018.
yes.
Acha. The executive committee of concern may, by public notification or by official order, levy or collect, fix or control revenue, cess, cost, charges payable, and may prescribe the manner and period which such are to be paid. So, where is this public notification
And
or official order?
two is there. Your Lordship may
Ah,
support
in
to
exercise of the power vested by the
section subject to the provision of section 22 of this act. The executive committee or concerned authorities shall be competent by public notification or by official order. A, to collect revenue from land pass holder as it may deem fit and reasonable. B, to collect and levy cess to the extent of 15% or cost or charges which may be increased or decreased and fixed by the executive committee from time to time by official order or notification from any landholder from the value of the land and on any other ground and in the manner as may be prescribed from time to time for the conduct of spot verification, survey and measurement or any other administrative work.
Okay,
or
so
other
where
ways.
is this? Where is
Page
this?
73.
73.
There is a notification at page 73, Your Lordship. It is dated 23rd September 2019. It's a notification issued by the Senior Revenue and Settlement Officer. In exercise, may I read, Your Lordship?
Yes.
In exercise of the power conferred by Section 23, subsection 2 of Mara Autonomous District Council, Land and Revenue Act 2018, Executive Committee of the Mara Autonomous District Council is pleased to notify for information of all concerned that the Executive Committee of the said Mara Autonomous District Council shall collect and levy revenue cess to the extent of 10% from any landholder from the value of the land and on any other ground and in the manner as may be prescribed from time to time for the conduct of spot verification, survey and measurement or any other administrative work or other ways as provided and envisaged under subsection 2 of section 23 of MADC Land and Revenue Act 2018 with effect from September 19, 2019, dated notification so and so.
No, you see, this is not,
Yes.
but this does not speak of acquisition of land.
It does not
Then
specifically
it only
say,
says conduct of spot verification,
yes, in connection
survey,
with
measurement, or
Yes.
any other administrative work, or otherwise
otherwise
as
as
provided
provided.
and as envisaged under subsection 2 of section 23.
yes, yes.
Then,
So, Your Lordship, from the value of the land, what is the value of the land? How do we measure the value of the land? When it is assessed, when the land value is assessed, the portion which has been assessed as the value of the land for the purpose of payment of compensation, that amounts to value of the land. If that is not the value of the land, Your Lordship, it does not mean that the entire portion has been assessed, but the portion which has been acquired has been assessed, and that value of the land has been clearly indicated in the assessment. So, Your Lordship,
This is pertaining to collection of revenue.
in that view of the matter,
Therein a taxes would come in.
this is not a question of acquisition. This,
in that view of the matter, Your Lordship, my humble understanding of this provision is that from the value of the land. Otherwise, it cannot be ascertained as to whether it has a value of this much or other ways. So, Your Lordship, when
no,
the land
you,
was
you
proposed,
see, when you look at the entire chapter, this is chapter 5. What is it? What is the job? What is the ultimate aim or the object of chapter 5?
it's a miscellaneous provision.
It's a miscellaneous, but for what?
It's
For
land-
what purpose? It's only for spot verification and measurement of a land.
Yes,
And that
And-
will be for what purpose?
yes. Spot verification in connection with land acquisition.
No. Where does it say
And
that? No.
No.
You
It
cannot
does not
add words to a statute. You cannot add words to a statute or give a different meaning which is not there.
Lordship, this provision of law was there.
You see,
and
you see the words. You come here at 23(1). The executive committee or concerned authority in its behalf may by public notification or by official order levy or collect fixed or control revenue, cess, cost and charges payable by any landowner
yes,
or pass holder. You see, levy or collect fixed or control revenue, cess. So these are all revenue tax. It points towards revenue tax. It does not point towards acquisition, compensation due to acquisition of land. Then you come again, and may prescribe the manner and period in which such revenue, cess and cost, land charges are to be paid and collected. It says land charges. It's not acquisition charges. It's not compensation for acquisition. This pertains to, it appears to point to the fact that revenue tax can be collected to the extent of 10%.
Yes. No, 15%.
Of the value of the land.
15.
Okay, 15%. Yes, 15% of the value of the land. There's nothing pointing
Lordship,
towards
from
compensation.
the value of the land, if if I take Lordship to section 22.
No, you see, you come to 23(2)(c) also. You see, collect 23(2)(a). To collect revenue. It says revenue.
Yes.
To collect
collect such
revenue
fees.
from any land pass holder as it may deem fit. It says revenue. It is, you see, this is, it does not talk of to collect a part of the compensation amount from the acquisition of land. It talks of revenue. Revenue tax. Then again, to collect and levy tax, assess to the extent from the value of the land and in the manner for the conduct of spot verification, survey and measurement or any other administrative work. Then come to C. To collect such fees, costs or charges for mutation from any land. D. To exempt certain land pass holders of payment of revenue. So these are all for administrative works and
That is true.
measurements and does not, there's no,
And,
nothing talked about, nothing spoken
for-
about acquisition.
For the purpose of acquisition, Lordship, land survey was done. A lot of input has been made by the district council authorities, which is not denied by the writ petitioners. And what has been charged by the district council authorities is only in that aspect, because they have made a lot of input. The entire land was earlier surveyed and demarcated for the purpose of collection of revenue, revenue tax. But as on in connection with the land acquisition, separate survey and verification was conducted, and what they have charged is only in that regard.
This Mizoram land revenue rules 2000.
That is not applicable.
No, that is not applicable. Therein there is a specific provision that you can for land and land acquisition.
Correct.
And
For compensation
75A,
from land. Yeah.
75A was also incorporated for that. But
Okay,
here,
then we want that.
they should have made a provision perimeter to that.
In fact, we can have it, we can put it as thing and dismiss it also.
But
If,
because if we are dismissing it, we will not hear the, and he is only on that point.
There's nothing on that, there's nothing.
May I take a lordship to the grounds of
No, what ground?
Grounds of
You show us from the law, from the statutory law.
that's
Where does it point towards cess being collected for compensation, from the compensation amount? Doesn't.
It does not specifically say that it has to be collected from the compensation,
That's,
but what has been clearly stated here, if I take lordship to section 22, just
page?
page
71.
71. May I read the lordship? No land survey, spot verification, and measurement over any land allotted to any person by the district council in accordance with the Mara Autonomous District Council Act 2011 and Mara Autonomous District Council Agricultural Land Act 2011 or any other law enforced in district council area shall be carried on by any person, government or non-government department or agency for any purpose except by district council. 2. In case any land is necessary for any purpose to be surveyed. So here, for the purpose of, if it is for the purpose of land acquisition,
Let us read, carry
yes,
on reading.
verified or measured, etc. The owner of the land in question shall apply for the same in writing
Constitution.
before the concerned authority and the district council and the
So
concerned
did
authority shall-
did the owner of the land apply?
Yes, on the basis of the application.
Where is that?
They
Where is
since-
that?
Since
No,
they-
no, you see, your 22(2) requires the owner of the land to first ask for the measurement to be done and the
In
survey to be done.
in
Now, where
fact-
is that? Or
in
is
fact-
it done by you?
No. In fact, when they said,
No, we cannot go by what you're saying. You've got to show
no,
us proof.
because of this additional
You've got
work,
to show us proof in your
when they
document.
approached this honorable court for verification of their land as to whether their land will be cut across by the road to be constructed. So they had applied before this honorable court. And this honorable court accordingly made a direction for conduct of spot verification. So that amounts to applying.
Okay,
They had
then.
applied before this
Okay,
honorable
then.
court. And shall apply for the same in writing before the concerned authority and the district council, and the concerned authority shall perform such required work as and when it deems necessary, and in the manner as it may deem appropriate. In certain case, the concerned authority may, on its own initiative, perform such needful work under this section as it may find necessary in presence or consultation with the landowner or otherwise. So very wide power is given for such survey, verification, and all that. And if it is not done by
Sixth schedule.
the authorities concerned, the landowners may also apply for it.
Collect revenue. Give para 2, respective engineer.
So he will say that revenue includes this.
That is the issue. That is, because if it is revenue, cess can come in. But that is the land revenue they are talking about. Whether that will also include the compensation.
No, it cannot.
It cannot.
Cannot include.
Land revenue they can always.
Lordship had made a decision in this regard regarding whether cess is to be deducted, deduction of 15%
That
cess.
was as per the 2013 or 16 Act.
2013, 2013, and
That was different. There was specific. It was the word was specific, I think.
yes.
Out here, there is no specific word.
No,
Let us see.
like here, in the earlier case, the cess was directed, to be taken by the authority of the revenue department. But that was on the basis of an amendment, which was made after the commencement of the acquisition proceeding. And it was not acceded to. But in this case, the act, which is of 2018, it was notified and it was in application.
You see, those other rules that you're talking about specifically said that the cess shall be from the compensation that is to be paid as per the assessment made for acquisition. Out here, there is nothing. There is no word of acquisition at all. There is no word of compensation also.
That is true. That is true, Your Lordship. Every word cannot be put in a legislation.
No, it's just
But
one
the thing is-
word, two words.
yes.
That's all.
But the thing is, Your Lordship, when the value of the land is assessed for that particular purpose, and when an application to that effect has been made,
Doesn't come in.
Your
Prima
Lordship,
facie.
say this section 22 subclause 2 is very clear on that. And the other fact is that the petitioners knew very well that these notifications are there.
That's end of time. I need to take it home. And some more work.
All the 3 are same. All the 3 are same.
What do we do? Should I keep it partnered or no? Should I keep it CAV or should I issue notice?
Issue notice and then get fixed.
Okay, we'll, because of paucity of time, we'll issue notice.
Not on merit, Your Lordship.
Huh?
Not on merit.
You're lucky. If you want it on merit, it'll take some time, but it might not be, you might have to take a trip down to Delhi.
Lordship,
So it's a concession that we are making to you due to paucity of time.
all right. If it, for any reason, my Lord, if it is admitted,
Heard Mr. Seelanand Zawa, learned senior counsel for the appellants, who submits that the judgment and the impugned judgment and order dated 21/11/24 passed in WPC number 103 of 2023, whereby the learned single judge has directed, where is that?
To refund.
To refund the cess.
Your Lordship, as submitted earlier with regards to the compliance of the previous order of the single judge.
You have already refunded.
Yes, Your Lordship, if I may produce these.
No, what have I said? Should be set aside. Should be refunded, comma, should be set aside. Full stop.
This is interest. Second bracket. Page 23 of the judgment.
23 of the judgment. 21, 22, 23. No, madam, this is only with regard to the interest.
Yes, Your Lordship.
He's on a different foot. You see, there were three aspects to the
Yes,
case.
Your Lordship.
Two of them he's not challenging. So one of the provisions he's not challenging is this, the interest portion.
Yes, Your
Now
Lordship.
the issue that has to
Interest
be
and-
decided is with regard to the cess.
Yes,
Okay.
Your Lordship.
Next. He submits that the appellants are not challenging the decision of the learned single judge with regard to the other two directions passed by this court. First up, issue notice returnable in 4 weeks. Ms. Lal Nundui appears for the respondents number
10 and 11, Your Lordship.
10 and 11, while Ms. Zairan Sampui CGC appears for respondents number 8 and 9. Petitioner, appellant to take steps for service of notice upon the response number 1 to 7 by registered post with AD within 2 days. Within the course of the day,
Within a week's time, you know.
within a week's time. List the matter after 4 weeks.
No place.
है ना?
Item number 2.
Item number 2 is in respect of
Same.
the same judgment.
Same
but
judgment.
there is a delay of 31 days.
Okay, same judgment we allow, 31 days. Okay, same thing. The parties' positions are the same.
Yes.
Same, except 31 days.
Position will not be same because the respondents are more.
Or response are more.
Yes, respondents are more. in the
Okay,
sense
okay. Then
writ
out here-
petitioners are more.
You write Ms. Lalnundri appears for the respondents number 77 and 78. Okay. While Ms. Zarem Sangpui, CGC appears for respondents number 75 and 76. Okay. Then out here you also write office note indicates that notice was issued. Same date, no? Same date, same date. So out here the others will be 1 to 74. Okay. Same thing, same issue. Mr. Ramzawa, same
Yes,
issue.
yes, same issue.
Okay, same
It
issue.
arises out of the same common
Okay.
judgment. But
Item number
here,
3.
3 is different.
Okay.
Third one is different.
Okay, third one, right. Heard Mr. C. Ramzawa, learned counsel for the petitioner, who submits that there is a delay of 36 days
Yes.
in filing the appeal against the judgment and order dated 25/11/24, passed in WPC 127 of 2023. Who appears?
Yes, my lord, I'm appearing for the respondent number 54 and 55 for state.
Ms.
respondent.
One ACME appears for respondents number 54 and 55, while Ms. Zarem Sangpui appears for respondents number 52, 53. So this also allowed, okay? Then in the main case, everything is same, I think, then notice.
Lordship, the manner in which it was dealt is a little different, but the thing is, Now, while making this judgment, the Honorable Court was adopting the judgment of the earlier, in the earlier case.
So this is also same issue.
Same issue, same
So
issue.
same issue.
Deduction
Same
of
order.
10%.
Same order.
Obliged.
But you'll have to, I don't know, you'll have to see, because there is not a whisper of compensation, there is not a whisper of acquisition, nothing is there.
Only word used is land value.
Land value, only land value. Land value is always there. You know, whenever the land settlement certificate is issued, land valuation certificate is always there. But that land valuation certificate is only meant for the purpose of fixing the revenue tax payable on the land value. Everyone has got LSCs, everyone will have a no objection certificate, non-encumbrance certificate, you'll have a land valuation certificate, and I think there's one more certificate. What is the certificate's name? I forgot. There's one more, that small one is there. So you'll have to, I think, we'll have to see it afresh.
Yes, yes.
Anyway, before we rise, we're having a program here this evening at 3 o'clock. The program is 3:30, but the two Supreme Court judges are coming, and we're having this the closing function of the environment campaign. So it's going to start at 4:30. It'll end at 5:30. Just 1 hour, and there'll be some tea and some other things. So you all are most welcome to please come and join in the conference room, all of you. Okay.
Grateful, Your Excellency.
For motion, item number 1 to 4.
Yes.
My Lord, with respect to item number 1, my Lord, this is the second time the petitioners are before this honorable court, my Lord. The
Why?
My Lord, I will come to them, my Lord. The petitioners are legal dependents of pensioners of the respondents, my Lord.
Pensioners
They're legal dependents of pensioners
who have expired.
my Lord. And on the death of their spouses, my Lord, the petitioners have been receiving family pension under the Mizoram KVI Board Pension Regulations 2002 regulations. And in the year 2019, the respondents had amended the 2002 regulations, my Lord. And as per the amended regulations, my Lord, the petition...
Regulations amended in 2019?
19, my Lord. And they were, the family pension was modified. And I have challenged the...
To the extent that?
To the extent
12
that...
months?
12 months, my Lord.
Then?
And I have challenged the amended regulations. And the Honorable Division Bench had...
So that amendment could not be given
retrospectively, my Lord.
Then?
And thereafter, my Lord, this petition is for directing the respondents to pay the petitioners the arrears and the family pension as per the 2002 regulations, my Lord. That is my case, my Lord.
So then, what is this contempt for?
Contempt, my Lord, I had filed this item 2 and 3 contempt petitions after there was no compliance of the judgment and order, my Lord. Judgment and order passed by the Honorable Division Bench, my Lord. Pension has not been paid as per the...
Then why are you filing the writ petition?
Writ petition, this is necessitated because, my Lord, I must admit that there was no specific direction in...
To pay.
To pay.
Then you withdraw the contempt.
Contempt, my Lord,
because there is another aspect of the matter.
If your Lordship is not inclined to proceed any further,
there
is
another aspect of the matter.
My Lord.
Whether the state can be fastened with the liability of the Mizoram Khadi Village Industries Board, that issue was not decided by the division bench.
My Lord, that's true.
That the division bench has also clearly clarified that. So that is the stand going to be taken by the state government.
That was also the stand taken by the contemptors in the contempt petition.
So that issue, unless it is decided, the contempt, because they are going to say we don't have the money.
That's true, my Lord. Since there was no specific direction passed by the Honorable Division Bench.
Correct. So maybe the contempt you
contempt,
withdraw.
I am not pressing it, my Lord.
You don't press this, we'll close it for the time being.
My Lord.
Close it with liberty to file at the appropriate time.
My Lord.
Because, so we'll issue notice here. Okay. So just write, who accepts notice? Yeah, Lal Rui for?
Respondent number 1, 2 and 3, your
One,
Lordship. 1, 3, your Lordship. 3, your Lordship.
And what about you, Mr.?
1 and 2, my Lord, I can...
What is your name?
Lelrod Puya Silo.
Huh?
Lelrod Puya Silo.
Lalratpuya Silo accepts notice on behalf of the response number 1 and 2. Okay. So, how much time do you want?
3 weeks time, your Lordship.
Okay. They are granted, the respondents' counsels are granted 3 weeks time to file affidavit in opposition. You see, one issue that will have to be taken into issue is because the state is going to say that since this KVI is a board, separate board altogether, they cannot, the liability of the board has to be paid by the board, and we are not going to be, we cannot be fastened the liability of paying the liabilities of the board. So you will have to take a stand also as to whether the liability has to be paid by you or by the government. Okay. Leave the matter after?
3 weeks, your Lordship.
3 weeks. Then in the IA, in the contempt, right, heard Mr. Sitlan Thiangdema, learned counsel for the petitioners. He submits that he does not wish to press this this contempt petition as on date, in view of the fact that the division bench of this court in WPC 10 of 2022, while disposing of 10 of 2022 and 11 of 2023, had not made any specific direction to the KVIB to pay to the petitioners the family pension, inasmuch as it had not taken a decision as to whether the state government could be fastened with the financial liability of the Mizoram KVIB. Huh?
My lord.
Correct? So he accordingly submits that the contempt petition may be closed with liberty to approach this court again at the appropriate stage. Who appears for the other side?
I'm appearing for KVI, my lord.
Mr.
Number 2 asylum.
Lalratpuya Silo. It cannot be for KVIB, it has to be contempt is
I'm
individual.
representing 1, 2, and 4, my lord.
Ms. Lalratpuya appearing for respondents number 1, 2, and 4.
Yes.
And you are there also, madam? No. Submits that. No, appears, just say appears for the respondents number 1, 2, and 4. Okay. On the prayer of the petitioners' counsel, the contempt petition stands closed with liberty to approach this court again when the occasion arises. As per law. Cannot come after 10 years.
And with respect to item 4, my lord,
Same.
a notice was issued on 10/3/2025, my lord.
Notice
Just this week.
item
number 4.
4.
It's also there, my lord.
Notice issued.
Notice was already issued on 10/3/2020.
Okay.
It's analogous with item number 1, my lord.
Okay, so that item 2 and 3 will be the same thing, okay? So what, then this was issued when? 10/3/20?
my lord.
Then why is it listed today?
It was listed because in the contempt order, my lord, it was
Okay,
Past that
because
it-
of that.
this
Okay,
matter
right,
may be
in
dubbed
in
together,
this
my lord.
case, you're right. The order dated 10/3/2025 passed by this court reflects that the matter has to be listed after 3 weeks. Accordingly, list this matter after 3 weeks. Acha, wait. He has not taken steps.
I have taken steps on 11/3, my lord, but it has not
But
been
he is
reflected.
coming here, he'll let him accept notice. End of the matter.
No, my lord, in this item 4, no one accepts notice on behalf of 1 and 2, my lord. Only government advocate accepts notice on behalf of respondent number 3, my lord.
That is why he's here. He can accept notice now.
My lord, my lord.
That's what I'm
I
saying.
can serve him a copy, my lord.
Yes, you can take it back from the registry if they have not sent it, because there's nothing here which says that the steps have been taken by you.
Yes,
So
my
you
lord.
take it back from the registry and give it
My
to
lord,
him.
my
Okay, right. Mr. Lalratpuya submits that he will accept notice on behalf of the respondents number 1 and 2. Full stop. The petitioner is, accordingly, notice is deemed to be served upon all the respondents. The petitioner is given the liberty to take back the copies of the writ petition that he had submitted before the registry for service of notice by registered post with AD. The petitioner shall thereafter serve copies of the writ petition to the respondent, to the counsel for the respondent number 1 and 2. List the matter after 3 weeks.
For admission, item number 5.
5. Item 1. Item 1.
May it please your lordship, I am appearing on behalf of the state respondents, your lordship.
This is again marks. That's only marks. You bring the marks, that's all, end of the matter.
MPSC.
Huh?
MPSC.
MPSC is to bring them. Who is for the MPSC?
Lord, I'm appearing Vichy.
So, you see, you bring the marks on the next day, that's all. This is again marks.
My Lord, it can be disposed of very easily.
Okay.
Now, considering, my Lord, may I please make one submission?
Yes, yes. Where is your gown, Mr. Counsel? So, you see, you bring the marks on the next day, that's all.
Yes, my Lord. Even it can be disposed of very easily.
Okay.
Now, considering, my Lord, may I please make one submission? My Lord, even
Why is there
if,
so much delay?
his,
Where is your gown, Mr. Counsel? So, you see, you bring the marks on the next day, that's all.
yes, my Lord, even it can be disposed of very easily.
What's happening?
Now, Considering, my lord, may I please make one submission? My lord, even
Why is there
if,
so much
if
delay?
his,
Where is the gown?
What's happening?
So, you see, you bring
He's
the mark
playing
the
on
next-
and on.
yes, my lord, no, even it can be this also very easily.
Okay.
Mr. JC, where is your gown?
My lord, now it's clear.
Where is your gown? Where is your gown?
When we appear VC, we normally don't wear gown.
Well,
I have
in my court you have got to appear.
yes, my lord, I'll
this
note it down.
this is not your court.
My lord, actually, yeah, I'll know that, my lord, in the future.
You see, wherever in Guwahati also, we always ensure that everyone wears the uniform. Whether you appear in VC or not, you have got to be in uniform.
I'll note down, my lord.
Tomorrow you will come with a T-shirt and you say that VC we don't appear with the shirt, white shirt and band. Why? Then you don't need to wear anything. You come naked also. How does it make a difference?
That's true, my lord.
Now you tell me, yes, how can we dispose of this matter?
My lord, actually, if that the contention is that that he was denied because of his qualification, even if his qualification is accepted, see his marks. If the respondent, private respondent, is still doing much better. If he was given full marks,
Let us see how he's doing better. Where's the marks?
Your Lordship, if I may.
My lord, it's there
Yeah,
in
just
the
a minute.
document itself.
In the writ petition itself.
In the
Okay.
writ
Petitioner
petition
has
itself.
annexed it at page 28, annexure 6. So,
Annexure 6, page 28.
Yes.
yes, of
Page
the writ
28.
petition. In fact, I've made this point at in my affidavit in opposition
Page
at para 7.
28. Yes, page 20. Page 28 is what?
Annexure 6 series is there of the writ petition. The petitioner himself has annexed it, which
No,
he had
annexure
obtained.
5. Page 28 is annexure 5. Part of annexure 5.
Okay. In the copy that is supplied to me, it's written.
Annexure 6 is page 55 onwards. What is this? Wait, huh? Wait. Oh, this is the maybe affidavit in opposition or what?
I am talking about
This
the
is affidavit in opposition. Okay, the writ petition.
writ petition.
Page 28. Yes, let us see.
So, 28 is the marks obtained by the petitioner.
Petitioner's marks. Okay, he's
Yes.
got 294.
294.
Yeah.
Yes.
And as the reason why he was not called for the interview is because the requirement is twofold. One is that you have to be a junior commission officer, not below the rank of SI. Now, he is a petty officer, he is a Navy officer working as a petty officer.
He
Because
is a
this-
Navy officer.
Petty officer.
He's a
in the
petty
Navy.
officer.
In the Navy.
Petty officer
In the Navy.
in the Navy, yes.
So one of the grounds that he was not called for the interview was because although it may be a rank equivalent to SI of the police, it is not a position of a junior commissioned officer.
Okay.
It's a non-commissioned officer. So that's why he was not called. Now in my
Is equivalent to SI.
SI in police,
SI in police. But but petty officer is not a JCO.
JCO, it's not a JCO.
Is
It's a non-commissioned officer.
Okay, it's a non-commissioned.
It's an NCO. Either way, Your Lordship, assuming but not admitting that he is
So
eligible.
let us see the advertisement.
Page 18, annexure 2.
Page 18, annexure 2, yes.
English translation is at page, I think the petitioner will be in a better.
Okay, yes.
So, in the second column, Center Commander, Mizoram Home Guard and Civil Defense,
Yes, yes.
pay level 8, said, Junior Commission Officer not below the rank of Subedar or a Sub-Inspector or equivalent in armed forces, police, paramilitary forces with a graduate or equivalent degree from recognized university. So, Junior Commission
Junior
Officer.
commission not below the rank of or a sub-inspector. Or a sub-inspector or equivalent in armed forces, police, with a graduate or equivalent degree from. So, if he has equivalent, if he's in an equivalent post and is a graduate, then he can participate.
So, like I said, Your Lordship, assuming but not admitting that that is the case, if we look at the marks secured by the petitioner,
It's less.
and assuming that there is a notification of the Mizoram government, in my affidavit in opposition I've annexed it, wherein it has been stated that in all at page 18 of my affidavit in opposition,
Page 18, yes.
here at point number 2,
Yes.
it says the principal guidelines in para 33 entries under subpara 1, 11 shall be substitute, namely, marks awarded to a candidate appearing in a personal interview shall not be less than 30% of the total marks allotted, and generally not more than 90% of total marks allotted for the interview. So the total marks for the personal interview was 50.
Yes.
Assuming that he had secured 90% of 50 marks, which would be 40, he would still have secured marks lesser than me.
So 400 shall not be less than interview marks shall not be less than 30%. Shall not be less than
Maximum
30%.
is 90%.
90%. So 90% of 400 will be how much? 360.
No. Interview only. Interview is 50 marks.
Interview is 50 marks.
So
okay.
90% of 50 is 40.
Okay. Yes.
So, and if your lordship can
So
come
if
to,
he and how much marks did you get?
I got 347 total marks, including my interview.
3, 4,
And he had secured 294.
So
in his
even if he got 40 marks, he would be 334.
Yes. Sorry, 90% is 45. I apologize.
Okay.
I was never appeared in the interview.
Huh?
I was never appeared in the interview.
No. Assuming you appeared in the interview, supposing you got say 100 out of 100, supposing you got 50 marks, then you would still be 244, less than his marks.
But his total cannot be taken into account at this stage because interview will be held afresh. So in the event of allowing this petition.
No, he would not have locus.
No. The interview has been held or not?
It was already held. The private respondent was already selected.
He's already
I was
selected.
never called for interview.
Correct. His total marks with the interview is how much?
347.
347. So how much did you get for your paper 1 and 2?
294.
294.
Plus, let's say 90% of 50 is 45. It would still be 339.
No, that is him. You.
My total marks is in the paper.
347 with the interview marks.
With the interview.
So if you got 50 marks out of 50 in the interview, you would still be less than him. You would be 344. So where is your case?
But we cannot go on assumption that he will get security marks in the interview. By the
What do you mean?
private
He
respondent.
got, that's what he's saying. His total marks are 3. He's saying 347. He's
No,
saying,
that is including the interview marks.
So, are you denying the fact that he got 347 marks?
As of now, that is correct, my lord.
If that is correct,
But my understanding is that my submission is that if in the event of allowing this petition, then I'm allowed to contest in the interview, along with the other, including the private respondent.
how many posts are there?
One post.
One post.
Yes, my lord.
So, you see, you got in your written examination, you got 294. Correct?
Yes, my lord.
Page 28.
Yes, my lord.
Now, interview marks, maximum marks is how much? How much is the total marks for interview given? And where can we know your marks? Where is it?
The next page in the writ petition, page 29. I'm serial number 1.
Okay. So this is not under challenge.
No.
Then end of the matter. Right. Heard Mr. Victor L. Ralte, learned counsel for the petitioner. Also heard Mr. Lalfa Kumar, learned counsel for the respondent number.
5. Sorry.
Ms. London Hui appears for respondent number 1, 2, 3. Mr. J.C. Lanu Sang appears for respondent number 4.
4.
While Mr. Lalfa appears for the respondent number 5. The petitioner herein has put to challenge, has prayed for What is this impugn notification 25-1 of
He
24?
was already appointed.
Huh?
His appointment.
Your appointment order. And this 23 to 24? 23 to 24, what is that?
This is the impugn, page number 27.
27. Office order. You are F. Lal Abzawa. So this is page 27 is 23 to 24, office order. And what is this other one that you have challenged?
The selection, the short list,
25-1-24. Where is this?
page number 23, wherein I was excluded, not called in the interview.
Okay, 23.
Even though I secured, I should be in the zone of consideration for interview.
Okay.
That is my case.
Okay. But then, now that is of no interest. Even if we allow that you should go for interview, it's a futile exercise. It will be an exercise in futility, because even if you get 50%, your marks will never reach his marks. Right. The petitioner has put to challenge the notice dated 25-1-2024, which is the list of candidates who have been asked to appear for interview, minus the petitioner. The petitioner has also put to challenge the office order dated 23-2-2024, by which the respondent number 5 has been appointed as center commander pursuant to the advertisement bracket 05 of 2022-2023 dated 29-3-2023, hereinafter referred to as the advertisement, issued by the Secretary cum Controller of Examination, Mizoram Subordinate Services Selection Board. Full stop. The petitioner's case is that pursuant to the advertisement for filling up the vacant post of Center Commander in the Mizoram Home Guard and Civil Defence, the petitioner applied for the said post. The selection process consisted of the candidates requiring to take part in the written examinations having total marks of 400, and thereafter interview for the shortlisted candidates, where the total marks that could be awarded was 50. Next paragraph. The petitioner's counsel submits that,
My Lord, instead of making a lengthy order, I will withdraw it.
you withdraw, okay. Mr. Victor L. Rate, learned counsel, heard all of them. Mr. Victor L. Rate, learned counsel for the petitioner, submits that he would like to withdraw the writ petition. The prayer of the writ petitioner's counsel is allowed. Writ petition is accordingly dismissed as withdrawn.
Obliged.
Item number 6.
Lordship, I'm appearing on behalf of my senior, Mr. Bilaram Menga.
How much time?
A week's time, my lord.
Mr.
Lomo Maralte.
Lawama, appearing for Mr. B. Lanamenga, learned counsel.
That be last chance, Your Lordship.
Learned counsel for the respondent is granted a week's time to file affidavit in the position. 24 matter. 24 matter. A week's time, he'll file it, I think.
Item number 7.
My lord, a similar prayer for this item.
Okay. You are for respondent number 1 to 3.
4, my lord.
You are for 4?
Yes, my lord.
Acha. And what about you, madam? Are you filing anything? You already filed. Okay. Same, huh? Miss Das Longma appearing for Bira Menga, counsel for the respondent number 4 is granted a week's time to file affidavit in opposition. Ms. Bira the CGC submits that affidavit has been filed by the respondents number 1 to 3. This is the matter after the week.
Item number 8.
All this is the matter after the week. Yes, who's appearing? Madam Lalnun Louis? Where is she? Disappeared?
She's here, my lord.
No, she's disappeared. Call them, call her, call the government. Why are they running away from this case? What has happened? Has he gone back to his house? No.
Not yet, Lordship.
He's scared to go back.
Yes, Lordship, as of now.
It's which village is this?
Sorry, Lordship.
What is the village?
Tenzol, Lordship.
Tenzol. That
Tenzol.
it's not a village. This is the only matter left.
Lordship, it's the last item.
Patha call bro, Patha type bro. Go, one of you will go. Type.
This is part 2, item 2, but our council is.
Okay, mention la kana jan madam.
She was here. I found her.
She was just here, but she knew the case. The last order.
Yes. She's supposed to file affidavit.
What to do? What to do? So this is a problem. This is a problem. But since we are sitting, since we have got to go as per the law, then.
Yes. Lordship, in this, like this matter, in WPC number 68 of 2024, Your Honorable Justice has made beautiful judgment, and we have cited this judgment also.
Yes, Your Lordship. I was on legs in the other courtroom, Your Lordship.
Oh, okay. He wants to go inside his house.
Yes, Your Lordship. In that regard, as already submitted in the earlier affidavit, Your Lordship, it has been opened, his house has been opened, Your Lordship. And he has 3 minor kids who... 3 minor kids, Your Lordship. And he's also in jail with his wife. So...
Wife is also in jail?
Yes, Your Lordship. So at this stage, Your Lordship, the court, the government cannot give special consideration, special protection for his safety. He's already guaranteed such safety and protection under the Constitution of India, Your Lordship. So in that regard...
No, but you see, there's something called protection on paper.
Yes, Your Lordship.
Now, where are the 3 kids?
Your Lordship, I'm not aware where they are. I'm assuming that they are with the family.
And what about this, the direction passed by this court in the last order?
Yes, Your Lordship. In that regard, I have been given a copy of the submission that they have made, but I'm yet to get a vetted copy, Your Lordship.
You see, the SP and the DC will have to come here if they're not going to obey the orders of the court.
Your Lordship, they have complied to the order. I have given the copy, but it is not a vetted copy yet, Your Lordship. So I'm not.
Well, I can't wait. You see, this is a question of personal liberty.
Yes, Your Lordship.
Safe, you see. The direction was to pass was to file the affidavit within 2 weeks, and that was issued on 13th February, and now it's 1 month. When can you file?
Your Lordship, I'll be able to file it within the next week, Your Lordship.
Who is going to file? Who is going to sign the affidavit?
Your Lordship, it will be the, I believe it has to be signed from their office, Your Lordship, the office of the SDU, Thendol.
Right. The order dated 13/2/2025 had directed the concerned authorities to file an affidavit within 2 weeks. Though a month has passed, no affidavit has been filed by the concerned authorities. Full stop. A last chance is given to the concerned authorities to file an affidavit in terms of the order dated 13/2/2025, failing which the personal appearance of the Deputy Commissioner, Serchip, and the SP Serchip may be called for. You see, I take these things very seriously.
Yes, Your Lordship.
Okay. And luckily for you, today is the last day. The affidavit should positively be filed. List the matter. Don't say that. List the matter on when? 2 weeks.
2 weeks, Your Lordship.
Today is 13th, 27th.
Yes, Your Lordship.
That's all.
Oblige, Your Lordship.
Part 2 hearing, item number 2.
No one appears for the petitioner on call. Accordingly, list this matter after a week.
Ini kan number 2 to 9.